Firstport Property Services Limited, Appellant, and Settlers Court, RTM Company and others, Respondents.
This appeal is about the extent of the statutory right to manage blocks of flats conferred on long leaseholders by Part 2, Chapter 1 of the Communal and Leasehold Reform Act 2002. The Act conferred for the first time a right for the flat owners in a block to take over the management of the block or other type of building from the landlord or from the third-party manager appointed under their leases through the medium of a management company, which I'll call the RTM Company, set up and owned by the flat owners. RTM is, of course, shorthand for right to manage. A problem of interpretation of the 2002 Act arises where, typically, the relevant block forms part of a larger estate with other blocks of flats, and services such as landscaping, car parking and security, the use of which are shared across all the blocks of flats, are provided by a common landlord or third-party manager, and the charges are shared among all the flat owners in all the blocks on the estate. I will call those shared services estate services. The question is whether the right to manage conferred by the Act upon the owners of flats in a single block extends to the estate services. In 2013, the Court of Appeal decided, in a case called Gala Unity Limited against Ariadne Road RTM Co., that the right to manage conferred by the 2002 Act did extend to the management of the estate services. To the obvious question how the RTM manager of one block would be able to share the management of the estate services with the landlord or with the RTM managers of other blocks and charge all flat owners for the services, the Court of Appeal replied that they would just have to reach a sensible agreement. The facts of this case have put that assumption to the test. Settlers Court is but one block among 10 in the Virginia Key estate, which also includes several rows of freehold terraced houses. All 778 residential units within the estate share the use of the estate services of the type already described. There are 76 flats in Settlers Court. Prior to 2014, they paid collectively about 15% of the overall cost of the estate services, which were managed by the appellant Firstport Property Services Limited, the manager appointed under all the leases of flats in the estate. Flat owners in Settlers Court set up an RTM company, the First Respondent Settlers Court RTM Company Limited. In November 2014, the respondent exercised its right under the 2002 Act to take over the management of Settlers Court. The respondent, backed by a number of the Settlers Court flat owners, claimed a right to manage or share in the management of all the estate services. The parties were unable to agree any regime for that shared management. The appellant went on providing the estate services, being obliged to do so under all the estate's leases apart from those of flats in Settlers Court, but the Settlers Court flat owners denied any liability to pay their 15% of the cost. The result was that from 2014 onwards, the appellant has been providing all the estate services, but recovering only 85% of the costs of doing so. A claim by the appellant to be entitled to charge the Settlers Court flat owners for the provision of the estate services failed before the First-Tier Tribunal, and it failed again in the Upper Tribunal, in both cases because the Gala Unity case was regarded as binding. A leapfrog appeal to this court, bypassing the Court of Appeal, was permitted, so as to resolve the question whether the analysis in Gala Unity was correct. We have unanimously decided that it was not correct, and that the right to manage premises conferred by the 2002 Act extends only to the relevant block, in this case Settlers Court, together with facilities used exclusively by flat owners in that block, and that it does not extend to the estate services, the use of which is shared with the residents of the other blocks of flats and houses in the Virginia Key estate. I give the lead judgment, with which Lord Sales, Lord Leggett, Lord Burrows and Lady Rose all agree. Lady Arden is sitting on this hand-down panel, but was not a member of the panel which decided this appeal. Our reasons are in outline as follows. 1. The Act speaks of the right to manage premises, and premises are tightly defined to include only the relevant building, usually the block, together with physical features near to it which serve that building alone. Contrary to what was assumed in the Gala Unity case, the definition of premises does not include easements such as rights of way over other parts of the estate, the use of which is shared by occupants of other blocks on the estate. 2. The right to manage given to the RTM Company is an exclusive right, unless it chooses to agree otherwise. That makes sense if the subject matter is limited to the block of flats whose owners set it up, but makes no sense in relation to estate services. 3. The Act contains detailed provisions which require an RTM company exercising the right to manage to notify persons who would be affected by the change in manager. They include all the flat owners in the relevant block, the landlord, and any third-party manager, but not any of the owners of flats in other blocks on the estate. That makes sense if the right to manage extends only to the relevant block, but not if it extends to the estate services. 4. The other flat owners are entitled to have the estate services managed exclusively by the manager provided for in their leases, and nothing in the Act appears to take that entitlement away, or even to require them to be notified of any change. On the respondent's interpretation, a company over which those flat owners had no means of control would become involved in the management of services on which they relied, without there being any contractual relationship of the kind to be found in their leases with them. They could not hold the RTM company to account, and the RTM company could not charge them for the management of the estate services. This is in sharp contrast with the relationship between the RTM company and the flat owners in the relevant block. They are entitled to become members of the RTM company with a say in its affairs. The Act amends their leases so that the RTM company takes over the contractual relationship with those flat owners which the original manager had. 5. Where there are two or more possible interpretations of a statutory provision, the Court leans against an interpretation which produces unworkable results. The interpretation favoured by the respondent and approved in the Gala Unity case does produce unworkable results, whereas the interpretation contended for by the appellant does not. I have already mentioned the problems for the appellant in the present case in being unable to charge the settlers' court flat owners for their fair share of the cost of management of the estate services. But it is easy to think of worse difficulties. Suppose that flat owners in each of the 10 blocks on the Virginia Key estate formed their own RTM companies. How would all 10 agree or cooperate in the management of the estate services or in the recovery of charges for doing so? The Act provides no sharing mechanism in default of agreement, and it has been held to envisage only a separate RTM company for each block. The result is that the appeal is allowed and the Gala Unity case is overruled. The Court is now adjourned.